पढ़ दो फिर से, यहाँ से पढ़ दो। इन द लेटर पार्ट ऑफ सूट प्रॉपर्टी स्पेसिफिक परफॉर्मेंस अटॉर्नी जनरल एपेलेट ट्रिब्यूनल इन ऑल प्रोबेबली। रुको आप बोलो भाई। पुट टू एन एंड पीपल ऑफ इंडिया सच बीइंग ए पोजीशन था, सच ए बीइंग दा यूज किया गया था। एक बार मैं देख लेता हूँ, कंफर्म कर देता हूँ आपको उसके लिए। ये था, हाँ, सच बीइंग दा था, सच बीइंग द पोजीशन। इन टोटो डिवीजन बेंच जजमेंट एजुकेशन मिनिस्टर ऑफ एजुकेशन, ये तो वही लिखे हुए पुराने वाले। एड इंटरिम इंजंक्शन, हाँ, शेडो ऑफ डाउट है। रिट पिटिशन सन का ओके, मिट गया थोड़ा सा। रिट पिटिशनर टेरिटोरियल जुरिसडिक्शन एडवर्स पोजीशन इन्फ्लुएंस के लिए आर एन से काट दिया। टेस्टामेंट्री के बाद में जुडिशियल ऑफिसर, और ये इन दिस एंटायरिटी, जिसका कर थोड़ा सा कर भी बनेगा तो फिर सीधा बनेगा, फिर तो ठीक है। इन इट्स एंटायरिटी, एंटायरिटी की डबलिंग है। अगर इन दिस एंटायरिटी होता तो फिर ये दिस बनता। आइडेंटिफिकेशन परेड पोस्टमार्टम एंटेमॉर्टम, ठीक है, लेसर और लेसी हो गया। जजमेंट डेटर जुडिशियल मजिस्ट्रेट। जो आउटलाइंस है ना इनकी उसकी, इससे पहले वाला जो सिंगल पेज दे रखा उस पेज को तो बिल्कुल अच्छे से मगअप कर लेना जो जजमेंट का है, क्योंकि ये वर्ड बहुत बार आते हैं और इन्हीं से सारी कंटेंट क्लियर होता है। PW1 का भी बना रखा है, PW2 भी हो रखा है, उसके अंदर काफ़ी सारे कंटेंट है। लिखो, कौन सा नंबर बताया था लास्ट मैंने आपको? अब आप लिखेंगे 169 और 160 170 में से। स्टार्ट इट। On the other hand, the respondent filed a counter affidavit stating therein that in a writ petition filed by one Avinash Kumar, this court has directed that the respondent may inquire into the matter regarding the employees who have obtained the appointment under the dying in harness rules on the ground that their father or mother were in service of the respondent and died in harness, and on that basis some inquiry was conducted and it was found that the birth certificate submitted by the petitioner appears to be forged. Further allegation has been made that after inquiry it was found that only to get an appointment in the police department the forged certificate of birth has been submitted by the petitioner. Therefore, the appointment selection of the petitioner is hereby cancelled. I have considered the submissions made on behalf of the parties and pursued the record. From the averments made by the parties in the writ petition as well as in the counter affidavit, it does not transpire that petitioner was ever given a notice and opportunity before passing the order impugned. Admittedly, the petitioner's appointment was of 1989. In case some inquiry as submitted by the respondent was made and a conclusion was arrived upon that petitioner only to get an appointment has filed a forged certificate claiming that his date of birth is 15/11/1969. Petitioner's case is that he has passed the high school in the year 1983 and certificate issued by the board was submitted, maintaining therein that the date of birth of the petitioner is 15th November 1969, the respondents have not disclosed the fact that from where they have inquired into the matter and what are the documents to show there under that the certificate submitted by the petitioner was forged. Therefore, in my opinion, it was incumbent on the part of the respondents to have a proceeding against the petitioner as provided under the rules. The regulations itself provides that in case of some misconduct, or if on the basis of some inquiry it has been found that a person has obtained the appointment by playing fraud, in that circumstance, unless and until the procedure of inquiry as provided under the rules is followed, no disciplinary action can be taken against an employee. It is also not the case of the respondent that after verification from the petitioner also it was established that the appointment has been obtained by playing fraud. Therefore, in view of settled principle of law, it was not necessary to give a notice and opportunity and to have a disciplinary proceeding against the petitioner, as it is settled in law that fraud vitiates everything unless and until it is established the procedure as provided cannot be by way passed. Article 311(2) of the Constitution of India provides for dispensation of inquiry in case a finding is recorded by the disciplinary authority that it is not possible and feasible to have an inquiry in the circumstances of the case. This court has taken a view in the similar fact and circumstances that in case at the time of appointment a caste certificate has been filed and subsequently it was found that the petitioner does not belong to said caste, in that circumstances without holding a full-fledged inquiry, the appointment selection of a person cannot be cancelled. In view of the matter, the alleged act or conduct of the petitioner was of at the time of his appointment while entering into services. Therefore, the same would not constitute misconduct during the service, as such order of dismissal for alleged misconduct could not be passed against him. In my opinion, this submission made by the learned counsel for the petitioner have got substance and deserves to be accepted. The trial court, on the basis of medical evidence, held that death of Seema was homicidal. As to the culpability of the accused for an offence under section 302, the court held that in the light of the evidence of father and mother of deceased Seema, it was clearly established that the appellant mother-in-law of the deceased was harassing Seema. The trial court also observed that it was true that in the first dying declaration, the deceased did not involve her mother-in-law, but it was because of the fact that she was asked by her mother-in-law not to implicate any member of the family of the appellant. The trial court noted that after the first dying declaration was recorded, the parents and inmates of deceased Seema had reached the hospital. The deceased could get courage to state true facts, and again the special judicial magistrate was called and a second dying declaration was recorded in which she disclosed true and correct facts. The trial court also noted that the special judicial magistrate was conscious of the fact that in the first dying declaration she had not involved any family members of her in law. A specific question was therefore put by him as to the reason why she had done so, and the deceased had replied that it was because of her mother-in-law who asked the deceased to do so. ये जो वर्ड है आपके 835 के आसपास वर्ड है और 110 की स्पीड है। नंबर है 169 और 170। टीपी लीगल से बोला गया कंटेंट, लिखा गया वो मोस्टली कंटेंट। टाइप कर लो, जो बेटर लिखा है वो टाइप